Well, esteemed colleagues, we are virtually not limited in time. To say nothing about the lunch, we should have it as well. So let us continue the discussion to have ground for discussion over lunch. Everything is working. Can everybody read me? Okay. And I think the lawyers would not be lawyers per se if we would pay attention to the documents and authenticated documents. That's why I move that we continue our talk by giving floor to Mr. Paolo Pasqualis, who is notary public from Italy, on the movement of authentic instruments in the field of international succession. And I think it's a good follow-up of the previous talk, and we might come to the conclusion that the regulation is not as terrible and awful as they say. Mr. Paolo, the floor is yours.
The floor, and thank you very much for this invitation. It's always a great pleasure and honor to be here in St. Petersburg to this extremely important forum. Don't know if I have the means to use my presentation. You see it on the screen, but probably I need this small tool. In any case, I hope to be able to remain in the 20 minutes. So the issue, thank you very much. The issue, as you can read on the screen, of the free movement of authentic instruments is not new, of course, but it is particularly important, in my opinion, and interesting in the case of a succession, an area in which it is more frequent, I suppose, the use of such documents. But just to state immediately, maybe a conclusion, we don't have, I think that we do not have yet a specific or enough developed doctrine on this subject. And we use, let's see if the presentation goes on, and we normally use the rules provided by the various systems of private international law and of international conventions. You know that in principle all legal systems are more or less open to the acceptance of documents coming from abroad, and the traditional rule locus regitactum tells us that it works normally like that, and the Hague Convention, I mentioned here also the Hague Convention of the 5th October 1961 on apostille, which is very well known, I suppose, provides some specific rules for to improve the circulation of, and the movement of these documents. And also there are more or less detailed national rules. But I like to underline that the free movement of authentic instruments, and now I'm referring especially to notarial documents, I mean our documents, our acts, arises two kinds of problems. The first is how to verify the authenticity. Let's see, yes, apparently on the screen, or we can say the genuine nature of a document, checking that it really comes from who appears to be the author. And this is not always easy, as you know. I'm trying to go fast, and I do suppose that the presentation is available or will be available in the future, and so you will check in more detail what I'm saying now. Because we have first, when we receive a document coming from abroad, we have certainly first to verify that this public document, official document, authentic instrument, was issued by an authority which had the power of doing so. And so we have to verify normally if legalization apostille are regular and, well, obviously, many times providing an official translation, of course. And we have to also question how do foreign documents fit into a system which is different. Because sometimes you can find some specific rules in the different legal system, but sometimes there are no rules at all. And so we have, I insist, to create maybe, or to improve, or to better define a doctrine, a specific doctrine. Because in order to answer to these questions, we have to recall the fact that our document, the authentic instrument, is a special document. It's not only a contract, an agreement, a declaration, but the notarial authentic instrument is a document drawn up by a public official, I mean appointed by a public authority, and drawn up in accordance with procedure rules that are determined by the country of origin of the official. And we can tell about it, and it is mentioned then, that also the rule auctor regit actum is applicable. We have to check if the rules provided by the legal system of the author of the act are respected. And this is because, obviously, this type of document, our documents, are requested by law for reasons of legal certainty that cannot be challenged, especially for particular important contracts. And so they have normally a legally binding force, and they are to be entered into public registers. So one thing is the fact that the notarial document is a special document, and another thing is to consider that the agreement could be regulated, could be governed by a different law. I mean, this introduces a distinction that I try to mark over there. The agreement, negotium in Latin words, contained in the notarial deed is one thing, one important thing. The notarial deed itself, the instrumentum, always using Latin words, is the document with a special characteristic. So please maintain clear this distinction. We must always distinguish between the law that regulates the agreement and the law that regulates the document. And so here I mark again the difference, negotia, the content of the contracts, instrumentum, and auctor regit actum, applicable law to the document itself. So maybe the core of the problem is, or better, the second problem. I have already mentioned the first one, how to recognize, how to check the genuineness, I dare say, of the document. It's one thing, obviously important. On the other end, the problem to be solved is how or can, in principle, a notarial authentic instrument drawn up in one country, according to the notarial rules of that country, have full value also in another country. And so to produce the effects, its effects always also in the country of destination, or how a document can replace another notarial document in the country of destination. Does a notarial authentic instrument maintain the same probative potential? Can a notarial authentic instrument be registered in a different country, in a land register, for instance? This is let's go fast. This is the problem defined as substitution problem. The national notarial authentic instrument may be substituted by a notarial authentic instrument drawn up in a different country. And what is substitution and in which conditions it's feasible? The answer comes from a very clear resolution of the Institut des Droits International taken in Santiago, Chile in 2007. And just I leave you read then completely in the documents, but just I want to underline some points. Because Article 1 of these resolutions, it is only a resolution given by a group of experts, nothing more. It's not certainly an international convention, but it has its importance. And now the black screen, no, it's not so black anymore. So substitution allows, Article 1 says, a legal relationship or act originating in a given state to entail all or part of the effects attached to a similar relationship or act under the law of another state. So clear enough, I do think. And then, and this is one main point, Article 2, equivalence is the decisive requirement in matter of substitution. It is based on a functional comparison between the rules of the law governing the effects of the legal relationship or act and the rules of the law under which the legal relationship or act was created. It's extremely important. It's maybe obvious, but it's extremely important for us. Just imagine a document coming from a notary public of one of the states of the United States and have a look to these definitions. Obviously, Article 3 says that substitution does not require the laws under consideration to be identical, of course. But Article 4, equivalence is determined according to the law applicable to the effects of the legal relationship or act which is the object of the comparison. And more important as well, when the Act, Article 5, requires the intervention of an authority, such a judge, notary, or registrar, an equivalent act by the authority of another state is substituted if the respective, and only if I say, the respective authorities exercise the same or similar functions, and could be a religious authority as well. So please do remember substitution, of course, frequently in the practice, but equivalence as well, that give us the real sense of the possibility of substitution, functional equivalence. Not all documents coming from abroad have or could have or must have the same value, but only the documents having some specific requirement, judging one by one, I dare say. And let's go back just a minute. Legalization is a different thing. It's not the mark of the functional equivalence of a document. Is only a sort of certification that says that the signing person acted in the function declared, but not anymore. So legalization does not ensure the competence of the authority issuing the document to actually execute the public document. This is the result. I like to quote a study of the British Institute of International Comparative Law, very well done, which says things that sound very familiar to us and very practical as well. So legalization does not ensure the validity. Legalization does not ensure the reliability of the content said by the Englishmen themselves, you see. So apostille or apostille, as in English words sometimes we say, is a requirement only similar to legalization, so it does not add anything else. So let's go on, because, let's see, I would like to say, well, this is a I insist on the fact that legalization and apostille leave untouched all the main theoretical problems I've tried to mention. But the example, the good example, comes from the new regulation already mentioned, the European Regulation 650/2012, which is, I insist, sorry for to my companion speakers, but it is already entered into force. It will be applicable to successions starting from the, that are going to be opened starting from 17th of August 2015, but it is already into force. So it is already applicable for we European notaries, belonging to the European Union. And so the regulation 650 gives us what I dare say it is a very good example of specific rules governing the free movement of authentic instruments, because its text gives us the definition of authentic instrument, Article 3, letter I, and the distinction between the concept of authenticity, I mean the formal of the document, and the content, the legal act or legal relationship recorded in an authentic instrument. So recitals 62 and 63, I will take maybe later on the time to better define what recitals are. But in the same text of the regulation, there are those definitions. And then Article 3 gives the definition of authentic instruments, and is a definition that perfectly corresponds to the concept that we, the notaries, have. I mean, a document in a matter of succession, formally drawn up or registered as an authentic instrument in one member state, and the authenticity relates to the signature and to the content of, please note, and recital 62 states what the authenticity is, an autonomous concept covering the elements, the genuineness of the instrument, the formal prerequisite of the instrument. And I leave you, then I will give you the time to read it. And recital 63 explains that the term legal acts or legal relationship recorded in the instrument should be interpreted as referring to the content and the substance. So two different concepts. Article 59 of the regulation governs the acceptance, and this is, in my opinion, extremely important. I do read it quickly. An authentic instrument established in a member state shall have the same evidentiary effects in another member state as it has in the member state of origin, or the most comparable effects, provided that this is not manifestly contrary to public policy or to public in the member state concerned. But I underline especially the fact that the regulation gives to a document coming from abroad the same evidentiary effects. It is the very first time in which the probative value of an authentic instrument is fully recognized in international text. I mean, we normally use, maybe we have already used many times such a document, but this is the very first time in which this is clearly defined and stated in an international instrument of such importance. And I insist on that on this other slide. The evidentiary effects, probative value, depend on the law of the member state of origin. So the document is in condition to travel abroad to have the same probative value or the most comparable value, due to the fact that not all the countries know the probative value of authentic instruments. But it's another very, very interesting point of discussions. And according to this special probative value, and according with the difference made between the document itself and the content, Article 59 follows, saying that the challenge relating to the authenticity of an authentic instrument shall be made before the courts of the member state of origin, courts who better know the functioning of the creation and the creation of the document. The challenge on the content Any challenge related to the legal act or the legal relationship recorded shall be made before the courts having jurisdiction under this regulation. So according to the jurisdiction and competence rules of regulation. You see the difference. From a practical point of view, Article 59 provides also that the document will be accompanied by a certification drawn up, complicated maybe, not yet issued by, not yet published by the European Union, but now we are waiting from day to day the content of this certificate. And Article 60, enforceability of authentic instruments. This is a traditional rule of European regulation. An authentic instrument which is enforceable in the member state origin shall be declared enforceable in another member state. So this is a rule already existing from 1968 with the so-called Brussels Convention, today Brussels I regulation. And so another important point that give us the idea of the importance and of the, how to say, the facility of circulation, of movement of authentic instrument in the European Union. All in all, to give a conclusion, the new European regulation on successions provides a series of solutions that will certainly help to clarify the main issues concerning the free movement of authentic instrument. I insist, definition of authentic instrument, different rules provided for challenging the authenticity and the content, provision of a sort of certificate of origin accompanying the instrument abroad. And I insist once more, acceptance of the probative value, enforceability. And I dare say that this gives us an excellent material for the creation of a general doctrine of the free movement of notarial acts in international arena, a doctrine that we do not have developed enough, in my opinion, till now. Thank you very much for your kind attention.
Спасибо большое.
Thank you very much. I think we have repeatedly turned to the literature. In this regard, I would like also remind to you the phrase of my favorite character, Scarlett O'Hara. I will think about this tomorrow. But there are some cases when there's no possibility to think about this tomorrow, so we need to think about this today. That is why, I mean, the succession issues are the issues that we need to take into account today, because tomorrow we might not have these opportunities. But we remain optimists so far. Mr. Besson, you have the floor.
Permettez-moi d'abord de vous dire le plaisir. Voilà. Madame le conseiller, Monsieur le Président, Messieurs les professeurs,
Madam Chair, ladies and gentlemen, dear colleagues, dear professors, my friends, first of all, I would like to say that I'm extremely happy to be here with you in this wonderful city, which inspires us to all the best. For me, it's a great honor to be here and to speak before you, saying or providing the experience that I have already gained. So, why notary are needed to govern, to plan the succession? Why we have to instruct taxation authorities or lawyers or bankers to do so? But the case is that notaries play the important role in our society. They are conductors or carriers of trust or confidence. This is accumulation of trust and confidence on the side of the clients and the society. So this is a required link or niche to establish confidence between those seeking justice and the state. Lawyers, especially good lawyers, they sometimes are biased because they protect, evidently, the interest of their clients. They are paid for that. And a good notary, they are unbiased. They work for the benefits of the society, for the benefits of years. Sometimes I'm asked to prepare the succession papers so that to express duly the will of the legator. Notary, they are willing to protect the will of their clients. I was happy to listen to Mr. Grimaldi, who talked about the compromise law. You know, in Switzerland, they always like to talk about Switzerland, about uncompromised approaches, unbiased approaches, and independence, and peaceful coexistence, and so on and so forth. But what is the succession? How can we plan it? First of all, we need to look into the future, to think about what can we do during our lifetime so that to ensure with all needed those who are left behind us. So we're trying to do everything in order to satisfy all the needs. So the good planning in the future would allow these persons during the hardships after this person dies or has died to do everything or to have everything. Especially I'm talking about those who are entitled to get this property. If everything is planned not so good, or plan is not as it should be envisaged or intentionally, then that would complicate the life of many persons, and they would have quite heavy recollections about that. So we are talking about the actions that should be taken in order to ensure the rights of this or titles of these peoples. There could be some challenges in this process. This reflects the international cooperation, but we have good instruments, good tools which are needed to be implemented for the benefits of the society in order to overcome the existing difficulties. Of course, 20 minutes are not enough for me to cover all the aspects and of these instruments. That is why I just provide a blanket view on the issues of planning, and I dwell specifically on some important elements. So, as I said already in the preamble, that a good notary is not only a person who does everything well, but also does everything in a good direction. To have a good consultant, to act properly in international area, and we also need to communicate with each other, to deal with each other. I'm happy to talk with the secondees who come in from many countries, including Russia. We try to enrich each other, so these are quite proficient, qualified persons. They are the best from you, from Russia.
So, such a notion as will, the will that is made by the deceased, it should be executed upon death, and there are 4 stages that could be identified. First thing, it is looking for the document. Normally the clients address you, and they set the task. They know what they have planned, and they can give you the goals, but they don't know how this could be done. They need a guide. They provide the ideas that might not have the required terminology, and so that's why the notaries should get involved to understand what is the underlying motivation information, then how to expressly embody the will, and before the will is embodied, it is necessary to look into the circumstances, whether that is executable, like move from one country to another, divorce, marriage, change of will, etc. And everything is possible in life, and there might be some kind of quarrels with the near relatives, the perceptions of reality might change, and so all this could be embodied. Well-informed person can indeed expressly talk about the will. So we as notaries dealing with the customers, we can inform them about the different forms of disposing of the will, and that kind of information could entail the legal consequences and the taxation effects of the decisions taken by the testator. The testator should take that into consideration, and so the awareness also covers the selection of certain options. That's what the counseling entails, and so the notary public in this case should provide the counseling advice to the client. It should not be the activity which is subjective. It should result in the clients to have the information in its entirety. So you understand that awareness and counseling are two types of activity that have a common interface. After all those stages, we come over to the stage of drawing up the testament, the text. There should be a text with the unambiguous, and I think it will be correct to relay the motivations of the testators to allow better interpretation and better understanding of the will of the testator, for after the heirs will have to deal with that. And so there are specific instruments to express the will of the deceased. One instrument is a testament, and it is the legal instrument expressing the will. There are different forms drawn by hand or certain forms, a public document which is drawn up by a notary. There are verbal, oral forms. There are even more exotic forms of testaments like the Berlin Testament, in Berlin Audio Testament, and it's quite possible that in the future there will be digital testament or video testament. But getting back to the present, of course, the testament is a very important instrument, and another one, and I use it quite often, is the so-called succession agreement. It is a contract, and the two parties express the will. This is a document that occurs in Switzerland and Germany, and this particular instrument can amicably resolve the matter. The heirs have their own interpretation of the will of the testator, and it arises in family conflicts, which might be quite aggravated, and it's difficult to control them. And so the harmonic relationship between the members of the family might be affected. So that kind of agreement might involve certain aspects of transfer of the property by the testator and the heir, and general acceptance. It might be testimonial renunciation or privileging a certain heir. It might be the transfer of business or the certain provisions about children working, or some guidance to the management, to the executive of the enterprise, or the dispositions with respect to the other parts of the property. So something that I always tell my clients: you have to talk with each other, you have to substantiate your positions, and that what I do as well, because that kind of contract should not be drawn up without us listening to the heirs. So what is it? The expression of the last will. And I make up a preamble, and the testator explains why certain actions are undertaken when expressing the will. And some heirs might contest the will, assuming that the testator, when stating that the deceased doing such and such things was misguided. And so that's why the preamble is very important. Then there should be the provisions making the previous dispositions invalid, because if there are previous dispositions, then it might confuse the situation. We might face the situation when there are a few testaments, and neither of these are avoiding the others, and we face the situation of chaos, and which results in the conflicts among the members of the family. Another is defining the circle of heirs. It is very important who the heirs would be. In civil law, the heirs might be entitled for inheritance. We are talking about the legitimate heirs, and so a certain share of the estate might be inherited. The heirs might be listed. They should be identified as specific persons, and at the same time the estate might be shared out to the unborn children, and it should be well defined in the testament. There are many more complicated issues when when the deceased is in jail, and certain decisions affecting the unborn child should be taken. So the testator should understand that, one, the estate will be shared out for certain heirs. Now, as far as the property transferred is concerned, it is important to understand which estate is shared out to the heirs, because if we have a case of the legitimate heir, then this particular share is determined. But if it is the heir by will, then the situation is quite different. So I would like to talk about usufructuary. I don't like that kind of things, because there are conflicting situation, like some might make use of the building, but at the same time there'll be no financial liabilities taken related to the additional costs, for example, and the heirs might get bare ownership for the property, but won't be able to use it. That is fraught with the conflicts. Of course, we should not splash out the baby from the bath tub together with the water, but we have to understand that estate management is a complicated matter, and I think we should think about sharing out estate. Now, about substitution. It is important to make certain provisions, taking account that heir might die, and it's necessary to make a substitution, and to replace it, to substitute it with another person. So it might be a substitution of that is applicable in Switzerland. It is the substitutions that involves the transfer of assets to a spouse, but at the same time this property is transferred provided the heir transfers this particular property to the children of the spouse that died first, who and those heirs not being, say, the in blood relations with the heir. So I would like to talk about certain preconditions, certain circumstances. There might be certain clauses in the testament, and these provisions should not be of amoral, abmoral nature, and for example, related to taking a certain position in the family business or preconditions of successful education. And I would like to refer to what Mr. Pasqualis has said. It's about adoption of the international norms and standards. We've been talking about the EU regulation on succession, and we know that the regulation will enter into force pretty soon, and so I might make certain provisions in my testament that will cover certain positions with the certain clauses, chapters of this particular regulation. So some obligations or liabilities could be transferred as well as a part of the testament, and this happens pretty often. Now, talking about the contractual provisions, it is important in the area of succession, and one of the circumstances could be agreeing to certain demands of the other party. Special conditions are related to underage children. And in Russia, there's a development of the middle class, and there are people that might have 100,000 euro, 200,000 euro in estate, and if parents die and there are underage children, there might be trustees. But is it really good if the children get hold of that particular amounts of money? Just imagine 18 years old and getting thousands of euros. The first idea that occurs is to get to the beach to enjoy life over there. So we should think about that particular aspects when the contracts are drawn up. We have the such things as alienation, and of course we live in our states, and we should understand that there are certain international aspects, and Mr. Becke and Mr. Grimaldi have been referring that people are traveling, they're moving from one country to another, and some other laws might be applied. There are differences in estimating the estate, or related to testimony renunciation. There are other minor things. I'm not going to cover them all. By the way, I would like to talk about the executor. This particular person is an important person, and And this is a task that is imposed upon us, the notary publics, who is in a better position, who have relayed the will of the testator, of the deceased, who can live and to arrange the relationship between the people, who is in a better position to represent the interests of the heirs, who can achieve a well-balanced distribution of the estate. We understand that lawyers will be defending their clients, and we will be the unificators. We will be uniting people. And the living are also part of the estate planning. Take the marriage contract, for example. We understand that marriage contracts can define the property share of the spouses, and there's a gift law because a certain property could be transferred inter vivos, and of course it will affect the effect covered by the testament. Another important thing is related to the company law, to the corporate law, because sometimes it is advisable to maintain the unity of laws, to employ companies as a vector of harmonizing relationship between the heirs. As an example, the companies might be instrumental. The company law might be quite instrumental and useful to define certain standards of on who would get the property of the corporation. To ensure the continuity of the business, there might be different standards applied related to established practices on who will be holding certain positions of importance in the companies. Of course, the testator is interested in the business to continue operating upon death, and we do that especially when it's a family business. We have to understand which of the few sons will or daughter take a certain post. They won't be nominated by name, but we should register and record what personal traits and properties should enable the heirs to inherit the business that would enable the companies to function even after the death of the testator. Since we're talking about the company law, I would like to refer a certain element of the US legislature, which is surprising for us. If there are certain members of the businesses, then the survivors inherit all the corporation or company intact. In our civil law, this is not possible because there is a reserved share, but the US individual companies face that kind of circumstances. It is in the common law. And there's another instrument that is not used at length in different countries, like in Russia, for example, and I would like to cooperate with the Russian notaries. It is the agreement on future inheritance, on future succession. In fact, the heirs might distribute certain shares, of course, with the conformity, with the compliance of the testator, but they can distribute the shares themselves, and so they can sell their shares. And if there is, say, an heir leaving the country abroad, of course, he would be interested in cash, so he might renunciate a certain share of his estate in favor of the others, and we shouldn't forget about the other instruments such as trusts. However, this is an instrument of the common law. However, no matter what trust is involved, whether it is Swiss or Italian or US citizen, we shouldn't believe that trusts are used to avoid taxation or anything out of negative reasons.
Sometimes they could be properly used, but we should be very careful in applying them. So these instruments or tools are limited only in your perception, in your mind, and you should give a proper advice to your clients so they have a proper choice. In terms of international planning, succession planning, as we have already talked about this, it depends on the nationality of the testator and depends on his the location of his property and residence, and sometimes of the religions. The international private law and international conventions and national legislation also address these issues. The Hague Convention. There are several Hague conventions. At least I found 3 or 4 conventions: Basel Convention, Washington Convention, and European EU regulation, which we mentioned quite frequently during this meeting, and which is quite relevant. Let's move to the national legislative systems, because there are different systems, dualist system and others. But what is more important for our clients is the money. So I try to be quick, if you don't mind. Skip several slides. Each time we talk about the succession, each time we mean money. And of course, the most greedy persons are not always inheritors or heirs. Some taxation system would like also to chip off a bit of money from the inheritance or succession, and in some countries the inheritance or succession taxation is quite high. So it's a rare occasion when you meet the people who refuse to pay taxes. But at least people are trying to reduce their taxation or taxes they pay. So the taxation is a tool which provides for some schemes to do so, especially in terms of succession. What are the taxation risks in taxation risks in succession planning? We have some limitations, and here I would like to mention some scientific articles dedicated to these issues. Of course, we are responsible to the product. For the product, we advise to our clients. It should be a working product and should be beneficial product for our clients. But on the other hand, we shouldn't incite our clients to violate taxation legislation in the country. So succession planning could be limited or maybe not limited, and criteria could be different. Maybe the recent residents in Switzerland, in Russia or UK, but in UK this definition is a bit specific. As you know, starting from the Crusades, the Great Britain, you can live without returning to the UK. You should leave something in the territory of UK in order to prove that And in order to prove that you are not willing to be a citizen of UK any longer, you should build something or should have something in other countries. We discussed the taxation issues in France and other countries where we pay a lot of attention to the last place of residence. Especially in Germany, and the Germans live in other countries, so they have some time limitations with this regard. There are also some restrictions with respect to the movable property. And we know that the Russian legislation also have some taxes on the movable property of the testator. We have also limitations in the Baltic Sea states and Italy. In Italy, there is a taxation system with respect to the shares of the enterprises. So they are subject to taxation even if a person lives in Russia. And we have the United States, which pay a lot of attention to the issue of citizenship or nationality of the testator. And if you have a bank account in the United States, then you pay taxes in the United States. I also would like to mention planes, yachts. So this is a very alarming call for the notary if he deals with such kind of property, because it could entail big debts. There is a risk of double taxation, and there is a risk of which we would avoid. These are risks that we should avoid by applying the international convention. This is our task, so that to give a possibility to the testator to avoid the double taxation. I would like to conclude by saying that we have to be responsible in our work. Our role is to serve the interest of clients, not only compile documents, but also to ensure the prosperity of our clients. Please consult, make good advice to your clients, better advice, just for the benefits of your clients. Why some people don't like notaries? Because sometimes people don't understand us. So clients should understand us. Thank you very much and good day. Thank you very much. I would like to thank the speakers, and I also would like to urge the Russian notaries, please love your clients, make sure that you are useful for the interest of your clients, and be wise in making advice. The Russian legislation is not idle, is not standing. We are evolving as well together with the world. We also provide some novelties. Of course, maybe not everything ideal, not all projects are feasible, maybe some projects require further discussions or consideration in order to be implemented. We're taking into account the foreign experience and other issues. I would like to give the floor to Madam Micheva, the Institute of Private Law, with a presentation of the project of the amendments to the civil law in terms of the succession law. We haven't heard this presentation. I think this would be the first time when this presentation is made. Thank you very much. I would like to thank the Ministry, and I would like to say that despite the roundtable is fully full with the presentations, I also would like to take this time and present the main objectives of these presentations. I don't have a so to say material presentation that would be made orally, but I believe what I is going to say would be very interesting not only for the Russian colleagues but also for foreign colleagues as well, who maybe could hear a sort of repetition of what they say, or maybe some new novelties. The private law institutes under the president, which I represent, in the form of state order, developed a small project of making amendments to the civil code. So we receive these instructions and we start working. But still, we would like that the results of this work would be used, and these draft amendments are not submitted to the State Duma or Parliament so far, but I think that would be the first material for continuation of discussion in order to find the proper subject of the legislative initiative. I would like to say that this project doesn't claim to be the comprehensive reform of the succession law. We're just trying to rectify the quite obvious, striking mistakes or shortcomings in our succession law. I don't think that we should blame the authors of the third part of the civil code for these shortcomings, for making these shortcomings, because at that time, the time of the draft of this code, it was very difficult to imagine what would be the succession mass of our citizens, which are also entering a new stage of the economic development, and how to manage this succession mass. And it's not by accident that many issues which we're trying to raise are related to the management of the succession. When we don't have the owner of the property, but still we don't have at the same time the proof of the property for other persons. We heard quite frequently from a business representative that it would be easier for business or for a businessman to manage or to plan its property during his interviews, or maybe to use a trust or to move his own property abroad, and maybe to use other forms in terms of ensuring the succession planning. And sometimes testators are mentioning the lack of efficiency of the notaries or notary service in Russia, or sometimes they say that these wills are recognized as not valid because the testator at the moment of compiling this will didn't understand what he's doing. When in Voronezh we met our colleagues and discussed this issue, and I asked a question: how many or what is the percent of the disputed wills? They said that it can never be a case, but according to our estimates, about 60% of wills, as according to the Supreme Court statistics, are disputed in this manner. So that is why the businessmen, they are afraid of being in such a situation. That is why our task at the present moment is just to create comfortable succession system which would spare us some risks or obstacles or problems which I mentioned before, and so that this succession system would allow us to be strict in compliance with the will of the testator, not only in terms of distribution of property, but also in terms of management. Talking about the distribution of property, we understand it very well. We have such a notion as compulsory portion, so this is an imperative which should be maintained. But during the management of the property, during the uncertain period of time when this is a sort of idle inheritance or succession, then during this period the will of the testator should be a priority. So the draft amendments which I mentioned do not contain currently the norms of procedural nature. This is related not to the fact that we don't know where we should include these amendments, but during such times of changes, besides the civil code, we expect to have a new civil and procedural code. We have already started working the work. It would be the work of the specific parliamentary committee. So our specific proposals, and we do our best, we would like to see that a new procedural legislation contain a rule on obligatory property value of the instruments. So far we don't have this. All the documents in Russia so far are equal in terms of authenticity, be it the agreement or contract which is a notary document or not notary. That is why we need to have this obligatory element which should generate the proper value. I don't believe that someone could challenge this idea, but those who are concerned about their work they are doing or professional services they are providing, I would like to say that we hardly managed to complete this work by 2014 because we have already started the work, enormous work on the new civil and procedural law. But from a point of view of material law, I would like to say that probably we would need to widen the provisions on the compulsory portion and maybe review the provisions on succession law in civil code and notary regulation. This regulation was adopted before new civil code, and norms of provisions of succession law was the vestiges of the past. They are in conflict with the provisions of the civil code. So far we working on a new law on notary service, and we would prefer to move some parts of these provisions of the succession law into the civil code, some part of the civil code. So in Russia, legislative work is quite intensive, has been intensified. We set up a lot of working groups and various agencies and institutions dealing with that.
These are the groups in the Ministry of Justice. Then there's an ongoing work in the Federal Notarial Chamber, and I would like to urge all the stakeholders to get united and to develop the new substantive and notarial standards and norms. A few bullet points on the announced draft law on amendments into Chapter 3 of the Civil Code. Being short of time, do not want to abuse you. I will just give you the bullet points for us to at least start thinking about it. So the first thing we believe, and many colleagues might agree, in under Russian law, the content and of the testament and the limits of discretion are either not wide or not defined properly in the law. For example, regarding the estate management, there's an article 1119 which reads about the limits of the discretion, and it just defines a narrow circle of the possibilities, and all the persons, the estate could be shared out, the heirs could be deprived, or other dispositions, but there are not that many dispositions. Regarding the management of the property, that the trustee could be appointed, and when we take the referrals and we then read the 1335 chapter regarding the authority of the trustee, the standards are narrow, and the majority of the Russians do not appoint the executor. This particular institute is not in demand at all, and the executor that is appointed will not be entitled with the right to vote in the company, because the Russian law is vague about it. And the other novelties, like the succession contract, and are not ready. Part of the law, however, our colleague Medvedev, together with Zaitsev, have been developing it, and they've been talking on the necessity, if not to liberalize the succession law, but at least to expand on the freedoms of the legal relationship in this domain. There's another session across the lobby, and they've been discussing the issues of the freedom of dispositions in law, and if you had been present over there, then you might understand that the Russian registration is treading quite carefully with the respect of the introduction of dispositionary norms into the legislative framework, into the applicable law. So right now we cannot accept that kind of instrument right away. Another bullet point, and from the procedural point of view, it is high time to switch over from the declarative nature of the testaments and taking measures to protect the estates. The notaries should take that kind of protection measures, because it is wrong for the notary to do nothing until the heir announces on his claims, and of course it looks ridiculous for the other jurisdictions, but that's the case it is in the applicable law in Russia. We wish that if a notary gets a notification or information about the death, and then if the notary believes that the notary can open the estates, he should do that. He should make a disclosure or public information in the newspapers and start legal actions. And I don't think the notaries will be pleased about that kind of proposals because the question will be how much would it cost, and I have an answer to that. And the pay that the notaries get for the protection of the estate is 600 rubles only. However, the other formal deed, notarial deed, it is issuance of the certificate with the estate of 10 millions. The charge could be 30,000 rubles. However, the activity to protect, to defend the estate is much more risky than just opening the estate. Another bullet point, and we should define the status of the executor and the responsibilities, the authority. We should eliminate unneeded link, because by the civil code, the executor just hires the manager for just like what the notary could do. I think it was the mistake of the Russian legislator. It was done in 1996 when an amendment was introduced. And I think the executor should be a direct manager. No extra link is needed, and many colleagues agree to that. Bullet point number 4, it is the period of protecting the estate, and notaries cannot undertake actions to defend until the 6-month period expires. And though there is realization that the virtual heirs could turn into the actual or factual heirs much later than the expiry of the 6 months. 5, we need clear-cut rules on trusteeships and what will be done, and it is an important issue for the country, like if it is the shares in the limited liability companies or the stocks in the joint stock companies. And we have listed here the amendments to Chapter 1173, and another issue that could be raised, no time though, it is the certificates for inheritance, and we have started this discussion a few years ago, and if I make that kind of proposals, my opponents would get into the disputes that we won't be able to finish. So I would like to only to announce the idea. It stands to reason that in Germany the certificates are issued to the subject without indication of the objects that are transferred. The objects are listed only at the express will of the heirs, and that this particular certificate of succession that just reads to the son of the deceased on the transfer of 1/2 of the estate, and it could be presented to any register, to any authority that is the register of the stocks, and it makes life easier for the heirs. I understand there are objections to this particular statement. We should talk about the tariffs and what charges, what fees the notary will receive. And I think quite plausible is the proposals to take into account the information technologies that is integral part of our life. And what prevents Russian notaries at the moment to draw up the closed testament, to have a CD or a memory stick, to have it protect copyright, to have it rewrite protections with the video message, and to have it in a sealed envelope. And I understand the civil code that talks about the commitment to paper, but well, still, I'm wrapping up the very last idea. I don't want us to consider all the draft document as something that is already completed, and neither do I want to consider it as a panacea from all trouble. It's not a remedy, because in the long run some of the stakeholders admit that the trusts abroad are established for a different reason. The businessmen said that they need to conceal their property from their partners, B, from spouse, and C, from the state. And so this particular interest and factor should not be ignored and disregarded. That's why we do not believe that the change of the succession law will bring back all the assets into Russia. Well, I can see that we have some controversial statements, and we will get back to the possible amendments to the succession law in Russia, which is under reform. There's much at stake. There are many things to discuss. It is too early to put a full stop to the Russian succession law. That's why I would like to give floor to the practitioners, to the practice, Vladimir and Gennady, and it's about there's an international element in their practices as well. And then I would like to give floor to Mr. Grimaldi, to my co-moderator, for an active exchange of opinions with the floor. Esteemed colleagues, we will be brief and concise, not much time left, and we have been suggesting that our talk might be cancelled, but anyway, we were told to go ahead. A few observations. First, when settling disputes, we come across the notion of the evidentiary effect. And in Russia, there is a principle of free evidence. It is reflected in all the codes, criminal codes and procedural code, and it is important, and the judicial power is based on that, and the courts just make use of this notion, the free evaluation of the evidence. And it is necessary to discuss the documents talking about the effects, and the notarial chamber and the doctrine supports this, the notary, that the notary acts have the evidentiary effects. And our colleagues from Italy made a very interesting presentation on the authentic instruments, and there is a trans-border effects on with respect to charging money. We have that particular agreement with Italy, Poland, and in the CIS. It's a Minsk Convention, and I've been looking for the cases, the precedents, and there are certain decrees of the Supreme Court, and they covered these particular issues, but anyway, it could be applied. And our esteemed colleagues, Monsieur Laurent Bessot, has been talking about estate planning, and we are referring to that, and sometimes our colleagues from abroad smile about that. Russia is a safe haven with respect to estate planning, because there is no tax on estate that is when the property is transferred. The tax is zero, because the reason for estate planning in many countries is to minimize taxes. There are no taxes on estate in Russia, so and I call upon our international colleagues, say, to live in Switzerland, to come to Russia to die. And Lydia has raised interesting questions, and if we introduce the protection measures for estate, and it is contradictory to the existing systems of accepting estate in large cities. And in large cities it is indeed inheritance without borders. And the notary chambers have certain units, but if it is the constituent entities that have switched over to a new system, it's not possible. And the issuance of abstract certificates of succession, it destroys the system of registration of ownership rights. To have the ownership right registered in the land register, you will have to present the specific document for the specific property. So it will be the it won't be the predicament of the notaries, but you will have to ruin the existing system. So that's it is highly unlikely that the powerful stakeholders would agree to change the system. So talking about the disputes, there are different groups, categories of disputes, and for us to choose a certain jurisdiction, and from this point of view, from the point of view of jurisdictions, we should pay attention to the following aspects. There are different natures of disputes. It is either contesting the deeds on the notarial deeds, or the disputes between the heirs. And we should take into account the conflict of law, of the substantive law that can affect the process. Like in accordance with the applicable law, when inheriting property, only Russian applicable law is applied. And according to Chapter 36, only Russian notaries are competent to provide or to certify, authenticate the rights of the people, heirs living in Russia. There are certain alternative and exclusive competencies of the Russian courts. If it is the real property, it is so. It is the court competency in Russia, and it is for the cases of exceptional jurisdiction. It is the competence of the Russian court if the fact occurred in Russia, or the claimant lives in Russia, that is, has a resident in Russia. As far as recognitions of the judgments are concerned, we should take into consideration the following circumstances. There is a principle of conventional exequatur. It is possible to recognize the judgment of international courts with respect to the succession, providing there is an agreement, a bilateral agreement between the two states. There is a practice of reciprocity, but it is quite rare, and it is necessary to take into account the international covenants when defining the competencies of notaries or courts. And while we were getting ready for this particular presentations, and we have agreements with Latvia, Lithuania, Poland. There is such an exotic norm and standards. If the testator dies in Russia, and if the movable property is the territory of the other country, then the notary in Poland might be deemed competent despite the residence or domicile being in Poland. This is possible. What are the recommendations? What are the conclusions? The disputes regarding the assessing the notarial deeds to observe the rules related to the register is the Russian court competence. The other cases, the other matters could be under the competence of either Russian or international courts. So what are the issues for discussions then? Whether we can recognize the foreign judgment if there is no agreement, bilateral agreement. Can we accept the deeds of foreign courts? Because we might receive English court judgment, like there is an executor appointed over there who is requesting information on the estates. Should we enforce that kind of judgments? Could we contest abroad the testament drawn up in Russia, and vice versa, if it is drawn up abroad and certified over there, and can we contest it in Russia? And could the Russian creditors in international court file suits and claims against the property of a Russian citizen which is located abroad? Sometimes the foreign courts deal with that, and then it is excluded from the Russian estate. I give floor to my colleague. Sorry, let me scroll up a bit, and we can send the PowerPoint presentation to all the attendees, and you might have a look at it in details. Part of the presentation is on judicial administration, that is on enforcement. It is also implementing the court authority when considering this kind of cases. The major goal of the court and legislator is to ensure the minimum standard of fair justice. It is Article 7 of European Convention, which is implemented in the Russian legal framework, and it is an integral part of the public policy in Russia, and it is also international public policy. So it should be done fast, efficiency, to provide a right for legal protection, and there are different procedural principles: the right to know, the right to be presented, the right for preparation for the legal procedures. And so what are the main obstacles? One is the location of the members of the dispute abroad. If they are over there, the issue is how to inform them, what kind of means could be used to be able to talk the enforcement, because the violation, the procedure of notification could be the justification of failure to issue the exequatur abroad. Another barrier is finding evidence abroad. And indeed, we should bear in mind that the litigations on succession cases are artificial for the very reason of getting information on the assets of the testator abroad, because without disputes the notaries cannot get access to that kind of information.
That is why it's not a rare occasion when such litigations are started in the territory of the Russian Federation or in the territory of the possible presence of assets. So this is another obstacle. And a well-known problem of establishment and application of provisions of the international or foreign law which are called to govern the specific elements of the succession case. So when the foreign will is disputed in the territory of the Russian Federation, for example, what are the means and tools which can be available to address these tasks or in terms of court proceedings? In order to overcome these obstacles, we have official and non-official things. From official point of view, we have several options to overcome these obstacles. So first of all, these are for Russian colleagues, and I would like to draw your attention to the comprehensive treatise on provision of legal assistance. We have concluded more than 40 bilateral agreements. We have well-known Minsk Convention, Kishinev Convention of 2002. And I would like to draw your attention that we don't have, I mean in Russia, agreements on legal assistance with major trading partners and major immigration countries. We don't have agreements with United States, Canada, Germany, Israel, Australia. So the most popular countries, as it turns out, from economic point of view, from economic migration, they are not covered by this treatise. And I would like to draw your attention to the shortcomings of this mechanism in overcoming these obstacles in considering the succession cases. So they are coming from different age. They were concluded during the Soviet period time, and they were not regarded as a systematic elements, because during the Soviet Union this was an exclusive case, I mean the succession case. This mechanism is outdated. We don't have a detailed mechanism on provision of legal assistance, and we don't have also the tools to provide this assistance. I would refer to the Hague Convention, and experience shows that these tools are effective when they are supported by the specific number of formulas or templates which are standardized that would make easy to provide legal assistance in foreign countries. So far our agreements do not provide for this. The second aspect which undermines the efficiency of these treaties or agreements is that they mix the issues to provide of provision of legal assistance in many areas, legal areas, matrimonial, contract cases, and so on and so forth. So the single comprehensive or umbrella regime applies to everything. That is why I would say that for this regime is characterized by a lengthy and not always efficient way of implementation. So courts should look closely and carefully to that once they are eager to choose the possible models. The other element of getting information and getting evidence is the universal conventions on specific issues which were developed or drafted in the context of the Hague Convention. Russia participates in a number of these conventions of 54, 65, 70 and 80 in terms of getting evidence in foreign countries. So the advantages, they are of universal nature, especially the recent convention of 65 and 70s. These are common models, common law and civil law. Plus, Another advantage is the extensive practice, which is constantly supported by the Bureau of the Conference. So we have specific recommendations in application-specific elements. Other advantages is that these conventions provides for multiple options of solutions, not only the direct interaction between the those who requiring this information and those who are responding to these requirements. Besides this convention of 65 and 1970, they can use a method of legal assistance as parallel implementation without coercion when the requirement or body notify about this information without applying to some jurisdiction or authorities of this country. And the next advantages is the amendments or additions to these conventions. Among the disadvantages is the lack of the developed legal infrastructure. So besides these tools, everything is done through the central bodies, which unfortunately not always quite active and quite actively and efficiently can prepare the preparation of the evidence or information to be transmitted to other countries. And some lacks of clear definition. We know about the legal wars between specific countries of the European Union and the United States, or specifically between Germany and the United States in terms of application of the Convention of 1965. So some other unclear provisions. We have some difficulties with the United States, who charge fees for the notification. So they block the implementation of this convention of 1965 because Russia believes that it should be done free of charge, while in the United States these are the things which is done by the commercial entities. So we joined in 2001 to the Convention on the Provision of Evidence in the abroad, but so far we don't have a central body to deal with these issues, and sometimes foreign countries requesting the information from Russia, they refused to continue with this case, and they claiming that there is no proper reciprocity because of the lack of this central body. That is why this model is not always quick and efficient in terms of provision information. Sometimes it takes 6 months to get the information. Next model, which is applicable in a case of lack of agreement, this is the provision of legal assistance on the principle of international courtesy. So all the disadvantages that are related to the fact that all states recognize this principle, but they sometimes fail to implement this. It's up to the discretion of the states whether to implement it or not. Each time we try to apply this principle in sensitive cases like Schneerson Library, a well-known case, then Orthodox Church in Nitz and inheritance of Rerich. Each time we get refusal, and these refusals were based on the international courtesy. And also another disadvantage is that the only channel we have here is the diplomatic channel, so you should proceed through the entire chain, through the consulate office in the country and so on and so forth. And there is no possibility of coercion to implement this principle, which is a very critical element. So this model is to a great extent inefficient and quite lengthy. The next way, unofficial way of getting information or provision of services. So we have some options as well. The first option is that in the territory of a foreign state, we can implement specific actions in accordance with the procedures of the court, which is considered in this case. The Anglo-Saxon courts sometimes use alternative methods. The advantage of this option is that all the actions are done by the interested parties in this dispute, so they are quite targeted. So we are not looking just at something without knowing what we are looking for, but the parties know exactly what they need and how can they get this information. As an advantage, we can say that we are guided by the procedural code of the court, considering this case. As a rule, that could ensure the quicker or shortened period of time in getting this information. Disadvantages: lack of coercion, high expenses. It is necessary to ensure the presence of your representatives in the territory of foreign states, which hardly be working free of charge, and risks of appearance of parallel cases which would challenge the competence of the court, considering this case, or the decisions which or results which were obtained in official manner. And among interesting models or options which could be implemented in the light of a new civil code of Russia, this is the model of authorized persons, when these actions are implemented by the persons authorized by the court and which are subject to the supervision of this court. We have the same advantages here as the case with the previous model, but this is the more objective manner. But of course, high expenses. Experience of the European Union, which advanced considerably in creating the efficient system of provision of legal assistance. This is the detailed regulations on getting evidence and information and services, provision of services. So they are also a tool to authorize persons in order to implement these regulations. We have a European network which includes 503 judges, which include executives and other officials, notaries and others. So this model is more efficient, it's working, it works and provides good results. And brief conclusions or recommendations. So in practice, the court considering succession case, it should use different methods of getting information or evidence from abroad, notifying foreign states, using official and non-official methods. So they should be done in parallel. And it would be appropriate to avoid exclusive use of the procedural mechanism by the courts. So this, which is not appropriate. The same, it's not appropriate, the Russian interpretation of the Article 3, which provides for substitution of the Russian law, the foreign law with the Russian law, if no evidence is provided in the due course. So thank you very much. I would be happy to answer your questions, maybe in the sidelines of this meeting. Thank you very much. We got a volume of information, quite interesting information, but I don't believe that we should also to listen to the feedback from the audience with respect to this information. Mr. Grimaldi, do you want to add something, or maybe you would like to get some questions from the audience? Thank you very much. I believe that the audience was quite attentive. And since we need to communicate to each other, I believe we need to give the floor to the audience. And I believe this is the right time for the questions and answers. Thank you very much. Microphone, please. Interpretation is not possible. Switch on the mic. The first question that for well-known reasons, no subject evidence. My question to the President, you said that the European Commission is preparing the template of the certificate, common certificate, which consists of 37 pages. Do you have the information? How will you address the issues regarding the compulsory portions, portional or partial inheritance? And can you say that a new regulation proceeds in terms of spirit from the idea of rejection of the compulsory portion? Do I understand correctly or not?
Thank you very much for your question. There might be a misunderstanding. I'm not sure. The compulsory portion is quite well known and is a legal standard in most of the European countries. So I do not think that the European succession regulation or the European certificate of inheritance will abolish or endanger the compulsory portion. But obviously, when we talk about the applicability of a different legal system, of a different succession law, and that applicable succession law does not have any compulsory portion, of course, there will be questions risen. And if I understood the speaker before me, Professor Garibaldi, correctly, he was thinking about applying the principle of ordre public to questions of the compulsory portion. So that might be a thing you could think of. I'm not quite sure if the EU succession regulation is really open to that thought. But anyhow, there will be questions asked. I do not think, though, that there will be a wide endangerment of the compulsory portion by way of the European succession regulation, because the compulsory portion is a too widespread legal institute almost throughout Europe. Thank you.
Oui. Je voudrais ajouter une chose. Le règlement européen ne modifie pas les droits matériels internes. L'Allemagne connaît la réserve, la France connaît la réserve, la Belgique connaît la réserve, leurs droits ne changent pas. Le règlement ne pose qu'une règle de conflit de loi. Et simplement, le règlement dit que lorsque la loi qui est compétente d'après la règle de conflit, donc soit la loi du dernier domicile, soit la loi nationale, lorsque cette loi...
Different rules are accepted with respect to domicile, and if it contradicts to principles of the court, then this particular law should be rejected. There is a referral, but for the judge from Germany or Belgium or France, the share is part of the international public policy. Let's take an example. For example, the Frenchman living in the UK dies, leaving his estate in France, and tomorrow, when the regulations come into order, it will be in force. It will be the British law applied. If everything is left over to the son and leaving nothing to the daughter, will there be a renunciation of this particular law because the principle of the French law is violated with respect to the compulsory law? This is an important issue and it is being discussed by the doctrine, but there will be no refusal from the compulsory. And how accurate is the list of the property, or is there just an indication of the describing of the property if the need may be? Who can answer the question, colleagues?
Just get the question again. I didn't quite have the translation. So you're asking about the specificities that are laid down in the certificate?
Let me repeat the question. Of course. And our colleague has mentioned that the content is supposed to be changed. The content of the certificate is supposed to be changed. Right now, the certificate lists the property that the heir would inherit. This idea will be dropped, and only the abstract share will be of the estate will be indicated. There'll be no detailed reference of what are the items of the property that is handed over, and so it will affect the proctive. So the question is, do you know what will be the content of the new certificate of the succession? So will it, which system would it use? Would it describe the exact items of the property or not, or just the shares of the property that is handed over, if it is known? If not, if I understand it right, the European certificate on succession will just list the share. There'll be no description of the list of the items of property. There'll be no. And this is the tradition of many countries.
Maybe I could just make another annotation. So it's exactly as my colleague said. The certificate itself does not specify each single item that belongs to the estate, but it names the heirs and the shares, the proportions, the executors, and other legal aspects, whereas what you're talking about, to our understanding, legal understanding, is a different thing. You can do something like that when you go to a court and say, I would like to have a specific list listing every and each single item belonging to the estate. You can do that if you want to, which is quite an effort, but it is not done on a regular basis with every certificate of inheritance. Thank you.
The certificate should not list the property that belonged to the testators, but it is possible. So if you know what the property is, fine. Just one word on behalf of the Russian legal system. we are scrapping the definition of the act of ownership right in its former interpretation. And the certificate on the right of ownership for real estate, by fact, it's not the document of ownership per se. It is only an extract from the register that certifies their right. That's why the certificate will, after issuance of a few days, it stops being the document certifying the ownership, because these stocks could be sold in a few hours. The shares that are listed over there could be sold. So use of the West European model, which is in the civil law, well, unfortunately, it takes too much time to discuss the practical use of these changes, but I think sometime later at a different site. I don't think we should be afraid of this particular certificate of succession. And we issue the certificates that are to be presented for the foreign nations, where we just indicate the share, and it works. And but all the other matters could be resolved in court. As a practitioner, similarly to my colleagues, I would like to say that the use of this certificate is to indicate the heir. That is, all the property is transferred to the heir, but of course a month later or years later it turns out that there is other parts of the estate, and we were not aware of, we might not be aware of this particular estate at the time of the inheritance. That's why we not give the exhaustive list of the equipment. And indeed, shares might be indicated, and as a practitioner, I agree to what Ms. Mikhaeva said. It is true, we issue that kind of certificates, as Mr. Gerasimov said, so we shouldn't panic. And an important fact, because it is not the document just that certifies the ownership right. It is just confirms that the share is might be transferred or is transferred to the certain things, and the heir accepts the share. So the position is correct. It might be unusual for the practice, but it is something that unites us, and we are coming to the same certificate. Your certificate is of 37 pages, though ours is on 1. Let me add something. This particular document that indicates the shares in the estate is not the final. Is of the proof of the estate, but it enables the third party to transfer a certain amount of money to the banks without risking liability. And this particular document is the proof of transferring shares of the estate, and in France and in the other countries, this particular certificate is issued under the authority of notaries, and of course the notaries verify what is written in the certificates, and the evidentiary effects of these documents arise from the responsibility of the notary issuing it. That's how it works. And another thing, it's about the notaries. French notaries, together with the certificates of succession, issue the certificate to own real estate, and so the document that explains what shares are handed over as inheritance, all the property is handed over to the heirs, and this particular document is entered into the public register. And it is not only the certificate with respect to the real estate, but it is with respect to the shares of the joint stock companies. If it is a car, for example, the prefecture demands that we should draw up the certificate regarding this particular vehicle. So there are a number of additional instruments. Indeed, we have been referring about the list. So what is a list? Inventory of the property. But the estate, it's not just a list of assets. It is the liabilities, debt which is inherited. So the heir is supposed to know what is the amount of the inherited debt, because in my country there is an institute, and in conformity with this institute, the heirs might renunciate the inheritance if they do not have the full list with the debts, so the liabilities are to be known as well. Everything is fine with the assets. We are always ready to accept the assets, but the liabilities is a problem. Any other questions? Esteemed, I can ready to take it from the floor. It's a question to our foreign colleagues. Is it possible to inherit it in parallel by law and by testament? Like one share is inherited by will and the other is by law, and if one half is by law, the other by testament, how will it be shared then? Because then the heirs by law might be first to claim it. Like one share is by law, the other by testament, and if I issue the certificate for a share to both heirs, and I issue part of the estate in accordance with the testament, so this work is in parallel. So do you make reservations that one half of the estate, with the exception which is inherited by law, or no reservations of that kind is made? Of course, there are two types of succession, by law and by testament, and of course there are cases when the heir gets by law or by testament, and so there are two approaches then, by law and by testament, and so one can choose either to accept the estate by testament or by law. These two forms are equal, and the certificate will have an indication that there is a testament in any case, and we will indicate the heirs or heir which are indicated in the testament. And if somebody is an heir by law and this person is not indicated, not included into the testament, and if the testament covers the whole estate, then too bad for that particular person. But if he has the right for the compulsory portion, he will get it. And of course we take into account the compulsory portion, which guarantees certain rights to the spouses and children. Right, we are neighbors and we have the same thing. We have all the things that are virtually the same. Our legal systems entitles the heirs by testament or by law to get their respective shares. They enter into estate in parallel, and in this case, the testator in the testament might transfer certain property to the specific person. That might be the only reason why the testament is made. And in this case, the estate is a sort of something that is transferred by testament or by law, and in this case the physical transfer of the estate is done by either one way or another, something that looks alike. All right, and I think we have come to an end of our happening, and I would like to conclude the round table by making some observations. It was very interesting for me to hear about the difficulties that occur in Russia during the transitional period, when we don't know who the heirs might be, or if there is a conflict between the heirs, and there are certain rules in the French law. The testator, before death, can appoint a trustee and make a disposition or instruct somebody that will be executing the will for a period of, say, 1 year or more, and if this is not done, then any person or the creditor might request the court to nominate the person that will be dealing with the estate. It's quite a complicated period, and the person died, and we don't know where the estate will be transferred. It's something similar to the trusteeship in the civil law, and another aspect, and it is international succession. When there is a conflict of law, and it is related to the existence of the equipment and its cost. The question is raised where the estate is and what's the price of this estate, and so there's a lot of conflicts involved, and that's where the international cooperation is needed. And trusts, as you have said, and as far as I am aware, all in legal practice of trust, when we deal with trust, it means that we have hidden our assets in Virginia Islands, and we have set up some shadow entities, and we don't know who this entity is owned by, and we understand that we should develop international cooperation to find the truth, and political will is needed. And if one state imposes its political will on the other states, the US are performing quite well. They're capable of doing that, but we want to do similarly. We want to know what assets are hidden in the US, and it's an important question for all of us. And the very last thing that I would like to say, it's about the estate planning. As a matter of fact, of course, it is very important and it is absolutely correct to plan for the transfer of the estate, and you have been talking at length how the notary publics can provide a helping hand over here, but I would like to remind you what the law prescribes, what are the legal standards and norms, and the law assists us in our doings. What we will is good, but we should observe the law, and the law should be the guiding standard, showing us the way that we should take, and it will help us in estate planning. We can proceed even further, not only do the estate planning, but we can predict and program succession in our life. Why do we need to do that? We live long and good, and if our children will be waiting too much for our death, they will get our estate not as a wealth but as a pension. They will become heirs when they turn 60. It might happen, but since we are living for quite a long time, we need to preserve our property. Well, because when we are old, we won't need that kind of property, substantial property. We won't need it all, and we might share it with the near and dear. Monsieur Francois Marillac used to say, "The old man lives only thanks to what he owns." Let us think about this particular phrase, but anyway, estate planning is a great thing. It is an important thing, and notary publics play a great important role over here. Notary public The notary public is a lawyer of reconciliation of sides, and when there is a conflict of law in succession, it's not only about money, it's about other things as well, because a person deprived of the estate or inheritance is aware that his parents preferred him or her to somebody else, and there's something irrational about that. It is fine for two oil companies to dispute. It's all about money. But when heirs dispute, there is no rational truth in that. In any case, the notaries help around to resolve that kind of disputes and conflicts. Thank you all. I would like to give floor to our charming counsel advisor to the minister.
Thank you very much, Professor. I think that this topic is infinite, and I think that we can move a part of the discussion and plan a part of this discussion for the next forum. So at least we have 1 year planning ahead. So I would like to thank all the participants, the audience, and it's not by accident that today we have the best of the best of the experts, and I would like to invite you to the next forum. Please make sure you have it in your schedule.